Okay.
Yeah. All right, we're back on record. Becky, you want to give a quick description of what you've done here, and then we can open the floor for comments, suggestions.
Sure. I've attended a concise summary of our discussion last time, which parsed our concern about legal advice needed by the employee herself and legal advice required by the municipality, and followed the track that we've discussed, which was that if this is a request which parallels the standard practice of the Department of Law to seek outside counsel in instances where the municipality lacks the internal expertise to respond to a legal question, even if that question is raised by a single individual employed by the municipality or a single public citizen, that we, again, see that as not a violation of ANC 115.020. Yeah.
And then Dee, you had a suggestion?
Just a clerical suggestion
Yeah.
was the very last paragraph I thought was repetitive. It had been answered in the summary and in the paragraph about that.
I agree.
Very succinctly.
Yeah, I think we don't need a last paragraph. And the only other suggestion I would have is that presumably this employee will require legal assistance. I don't know that we need that sentence.
And that is where?
That's in the first paragraph under discussion. Presumably this employee will require legal assistance. Why is that in there?
I kind of put that in there to tee up our distinction in paragraph 3 to say that there's basically two bodies of legal advice that we see potentially at play here, and to make clear that to the extent there's a request for legal assistance required by the employee to navigate her way through the visa process,
Sure.
that is one category that we have not really addressed here. I phrased this to say that may be a violation, but we didn't reach a conclusive decision on that because we don't need to. That's not the question before us.
Okay.
But that the second bucket of advice the muni needs, we see as not a violation of the code.
Yeah, I wanted to make sure that wasn't confusing to the extent that this would imply the municipality would be paying for legal advice or anything like that. But if it's clear for everybody else, then we can just leave it in, I think. And then, my only suggestion, too, is the last paragraph. Just delete it. Anybody else have any suggestions? Really?
I know.
Wow.
Say like one word.
Yeah, no.
You're missing one little word.
Where are we missing the word?
I think it's the third one here, the key, order to remain in Anchorage and be employed by the
Need to be, okay.
Yeah, be employed. But that's it. That was really good.
Can you tell me that so that if I'll have
Say
to...
it again.
Yeah,
Obtain a
it's
new
right
work
at
visa
the
in
top
order to
under
remain
discussion, that third.
in Anchorage and be employed,
Yeah,
right?
be employed by the
I just don't know where it's at.
Remain. Well,
Request obtain.
in order to remain in Anchorage and employed. Remain employed.
Yeah, that was my.
Yeah,
I
that
had
would
I
be
had phrased it
Oh,
to be
you're right.
remain
Okay,
employed,
you're right.
but I'm happy to have it be.
No, I.
If you
Yeah.
like it without the B, that's fine.
Yeah.
I don't care.
Yeah. Yeah, no, that's great. Thank you very much, Becky.
No
for that
problem.
work. Yeah. Typically, I had one of these drafted, and man, they tore into it. Tomorrow, so.
Oh, I remember that.
Yeah, I remember that. That was really dramatic.
Being
wasn't
nice
it?
was
Yeah.
my first.
No, I know. It was. Yeah, you were particularly hard. Yeah.
The word rejection takes on a meaning.
Anyway, thank you again very much. Yeah. So, with that one correction, essentially the only correction is
I
that.
got one.
Oh, yes.
question, I'm sorry. Yeah, right in that same place, where presumably this employee will require legal assistance in order to navigate the visa application process. Now, we shouldn't give a attorney for that.
No, we're not.
Okay.
No, and that's funny. That's exactly why I kind of that
Yeah.
sentence struck me, is because I want to make sure it's clear that this is not what we're.
I mean, if she uses that, then it would be
it'd be her cost.
right.
I almost
Yeah.
wonder if the paragraph after that should maybe be moved down further in the page. So in paragraph, in the discussion section, paragraph 1 makes that distinction, and then paragraph 3 picks the distinction up again. Maybe paragraph 2 should sort of come at the end of paragraph 3. So you make the distinction, then you say there's these two legal needs here, and we see a clear distinction in
Right.
them. One's okay, one's maybe not okay.
Right.
And then in offering the sort of like the reasons for why we think the first category, the one category is
Distinction.
okay, then we can include at that point paragraph number 2 saying, by the way, the Department of Law doesn't
Sure.
have this expertise.
What if we took paragraph 3,
Mm-hmm.
bumped it down here, and then basically bumped this last sentence of paragraph 2 to the end of that paragraph 3?
Yeah,
Because I think
that's
that one goes to the Department of Law's role and is sort of premature if we don't have this paragraph.
That's exactly
Yeah,
right.
oh, you
Yeah.
did. Excellent.
Yeah.
Okay, I agree.
Now you have to state on the record.
No, that's very good. I think that makes sense. Just clarify. That's funny. That's exactly what I kind of thought about that one sentence. Is want to make sure that it's not confusing.
Okay.
So that makes sense. So what, if I can summarize, it looks like we're in paragraph, so we number these 1, 2, 3, 4. 4 is being deleted. Paragraph 2 will be moved below paragraph 3. And the last sentence in paragraph 3, any advice to sponsorship, will be the last sentence in paragraph 2. Is that correct?
Yes.
Can you say that
Which
last
is now
one
the
again?
new 3.
The last sentence of the.
Right, the 2
Yeah.
is the
Yeah, well,
new
maybe we
3.
put it this
Sorry,
way.
yes,
The
your
paragraph-
multiple numbers.
Paragraph.
Yeah, it's gonna move up to the bottom.
Paragraph.
Paragraph 2 goes below paragraph 3. And the last sentence in 3 goes to the bottom of paragraph 2.
It's the last sentence of the opinion. Yeah, that makes a lot of sense to me.
Right. Does that make sense?
I got it. Mhm.
Okay, all right, good. Okay, with that, move to approve? Any objection?
No objection.
No objections to approving it? Awesome.
Lisa, do you want this back?
No, I don't need it. We'll throw it away.
It's approved.
Okay.
So now, what we're 8A, I think, is what we're going to look at, right? Has everybody had a chance to review this annual report? I want, just on the record again, to really commend Lisa for her efforts on this, because I went over this in detail, and when I go through this, it just really strikes me as how much effort she put into this, and how awesome this review is compared to other, not necessarily ours, but I mean, it's a really interesting read, and so hopefully this will get the attention of the Assembly. They won't just toss it aside, they'll actually read it. And this is the best chance we have of getting the attention that I think it deserves. I made some minor corrections, suggestions. Is this the same?
No.
Oh, this
the
is the
one
new
I
one.
just handed out, I put in all of David's
Okay.
edits, except for when you get to, I'll just tell you, I was doing it at the Assembly meeting last night and I ran out of time. So when you get to the end, he suggested an introduction to this recommendation and to make this look like, to indent it so that it looks like separated, and then to write a summary paragraph, and in truth, I haven't done it.
Give him the summary paragraph.
Yeah, but
Okay.
I figured that I could send that to David, because it's
Yeah.
an executive summary, and he could okay it,
Gotcha.
and we could still get it out.
All basically, just so you know, too, the difference between what's in your packet and what's in here essentially are just some stylistic changes to change passive verbs to active verbs and things like that. I mean, nothing really substantive is in the first couple of pages. And then the suggestion that we had is on the last, the disclosure of potential conflict of interest on page 16. I suggested putting it under recommendation, because we said in the first paragraph that we give a recommendation to the Assembly, and also set it out as this is what we gave to the Elections Committee, as opposed to just having it hanging out at the end, which to me was, I was kind of confused. I wanted I wanted the memo to fit in the annual report rather than it just be the last 2 pages of the annual report. And then at the end, full circle the annual report to have a conclusory paragraph that mirrors the first introductory paragraph. And that's it, just to make sure that it fits inside of the annual report. Does everyone want a few minutes to review this, or are we, any questions, suggestions, concerns, anything that like I say, what's that?
I have a
Yeah.
particular discussion point.
Yes.
On page 15, the
15.
first full paragraph, we're talking about disclosures and saying how the disclosures have improved. You know, from 41 now up to 211. And it says, although these numbers are vastly improved, there are close to 700 municipal elected and appointed officials, so the gap still remains, with some pushback from elected officials, lack of follow-through, changes in administrative staff, that this effort has stalled. One of the concerns there is that the elected officials, the Assembly in particular, took the, until we do a code change, they are not required to do these disclosures. And they're going to go right to this section and say wrong. So I would reword that, and of course that I haven't done.
I'm glad, because I thought that was kind of negative, so
No, I
I
agree.
forgot about
Yeah.
it.
No,
Yeah.
no, I-
Because
yeah,
as far as I'm
absolutely.
concerned, they are in full compliance. We need
Mhm.
to change the code if we had a debate with the elected officials that we wanted them to fill out our disclosure forms. The code is currently written says they only have to fill out APOC. And APOC is, 15 pages of detail that we don't need, doesn't identify municipal contracts, which is what we do need. But they have steadfastly said they're not gonna do it until we change the code. So they are in compliance.
Mhm.
So,
Very close to 7 years ago. Officials. Mhm.
Yeah, I'm sort of wagging my finger. I
Mhm.
don't like it.
No,
Yeah.
no, I agree.
I mean, I wonder if we just took out from although all the way down and just said, continued efforts including a code change for elected officials are being undertaken.
Yes, that sounds good.
Something
Yeah.
like that. It's an area that needs to be continued.
Yes. Good. Okay. That's good. Any other suggestions?
Now I have on page 6,
Yes.
you know how I am, language is over the top.
Yeah. No.
In the bottom there, we appreciate you, 2 years ago while reviewing gift disclosures, the board was alarmed by the lavish, some of these words just kind of pop out. So
Yeah.
I would suggest,
Right.
deleting that first sentence and just say some examples of excessive gifts received by teachers from the students, apostrophe, I assume, students' parents, included cash, parentheses, sometimes well over $100, clothes
Mhm.
parent, diamond jewelry, just make a statement rather than
Mhm.
alarming and lavishness.
Mhm. No, I think that's great. Yeah.
So you're suggesting scratch the word alarm or?
So just take out this whole first sentence
Yeah.
and just say some examples of excessive gifts.
Yeah. It makes, written like it is, it makes you believe that the previous ethics board didn't do their job.
Yeah. No, that's
Which
great.
is probably true.
Speak for yourself. Huh?
Okay. Great. Any others? Yes. Yeah.
On page 14, if you look at the first full paragraph, very confusing in one long sentence.
Mhm. Is that one sentence?
Yep.
Nice.
Faulkner ass.
Yeah. Wow.
It's, and I was reading through maybe parts of the third.
Yeah.
Can I make a suggestion? Maybe while we're sitting here today, I'll try to see if there's something I could rewrite, and it would only clerical.
Yeah.
Obviously the point being that we do need to. I guess we should say why we think this, because that was a pretty colorful NOPV. It is on the website now, so we're not disclosing anything that shouldn't be disclosed.
Mhm.
But just clean that up a little bit.
Yes.
Okay,
Please,
so I'll
thank
do
you.
Yeah.
that.
No, that's great. Anything else? No? Okay. What I propose is that Dee and I finish fiddling,
Okay.
but nothing substantive will change like this. And then we get this out before our next meeting, that we just get it out as soon as Dee and I finish editing. Does anybody have an objection to that? No? Oh, very good. Then, move to approve? Any objection?
Move to approve.
All right, so passes, this thing will be sent to the assembly, I assume.
It'll be sent attached to an AIM.
Okay, all right.
Oh, and I just wanted to show you, it's
Yeah.
not gonna look like this.
Yeah.
We're gonna have it printed up like this, so that we have, and so that's why you'll see on some of the next pages it looks kind of like they go together. It's because they will go together, so we'll have a pamphlet.
Perfect. Good. All right. Very good. So now let's get back to. Let's see, what did we have next?
Get back to new business.
Disclosure of. Oh, that's right. I did mention that, didn't I? What was my?
Well,
What was my
we have
conflict?
the,
Here you go.
This is new business. Disclose potential conflict of interest.
Here's your
Oh,
email.
yeah, that's right.
I don't know if
Okay.
you want these passed out. That's why I didn't put it in.
Right. I had. That's right. I forgot that I was going to bring this up. Did you see this email?
I don't remember.
Oh.
Yeah.
Well,
I
here's
sent an email to
copies
Dee.
if you want everybody to see it.
Uh,
Oh, yeah.
right. I don't need to pass this
Okay.
around. I'll just say it. I had signed a. I have signed a contract with as conflict counsel for a co-defendant, co-defendant case, criminal case on behalf of the municipality. And just for those who aren't familiar with this process, basically the City Public Defender's Office, which is Denali Law Group, they represent all indigent clients. And it is not common, actually, to have multiple defendants in city criminal cases. In the event there are multiple defendants, the Denali Law Group cannot represent more than one at a time because of conflict of interest with the other co-defendant. This is a 4 co-defendant case that came up. I was contacted by the city to help represent the 4th co-defendant. And so I agreed and I signed a contract with them. I don't expect that the representation will last more than a couple of months. It has nothing to do with this stuff that's going on here. If it does, I will certainly mention it to everybody. So I just wanted to make sure that that was out in the open, that I had signed a contract with the city over this issue, and that the contract will terminate as soon as the representation terminates, which I expect to be in the next 60 to 90 days at the latest. So I just wanted to toss that out. As far as right now goes, I don't see any potential conflict, but for the board to know.
Well, so I personally don't see where you need to fill any paperwork or anything, but should you, at a later date down the road, feel like there is a conflict, then maybe
Sure.
we should have a paper and it will decide whether or not it is.
Okay.
But at this point, I don't think so.
Okay, so I just want to make sure it's open for the board for discussion, if there's any discussion.
I was going to say, I did review, by the way, membership qualifications, and board member can't hold current employment with the municipality, not an independent contractor. And I'd also point out that David is against us in this litigation.
Right, yeah. This is not
It's
in the
adverse
interest
to
of
our but in favor of the constitutional protection for the defendants.
And Dee, were there any issues about him securing a municipal contract? Is it like, was it a bid contract? Was it no bid?
I don't know. I'd assume it was a sole source.
Yeah, it's Steve Brister contacted
It is
me.
the sole source. The smaller contracts, probably under $5,000.
Yes.
I assume don't have to go through the big process.
Right.
Okay.
In fact, I wasn't even aware of it either because it went through prosecution.
Mhm.
So he doesn't have to file a notice of intent to solicit or anything like
No,
that?
no, because it's so small, it's outside.
Okay.
Perfect, good.
Right, yeah, because that was the only way, because I don't think there's a conflict of interest. That would just be the only concern I have, that there's technical issues about
Yeah.
who can get a contract with the city and who can't if you're already a member of the municipality.
Now, there's a cap amount on it that's in excess of 5,000.
Yeah, not to exceed.
Not to exceed, but I don't think we're going to get anywhere near that amount. I don't know if that affects my disclosure filing
Well,
requirements.
no, it doesn't. If
Okay.
it was over that amount, though, then prosecution would have had to gone through me
Gotcha.
to the procurement
Okay.
process. And I think that is important that I wasn't part of that process.
Okay, perfect. Good.
Can I ask a related question? I mean, this just flags for me something that, so for instance, I mean, per the disclosure that I filed that we looked at last month, I do a lot of work for GCI that involves engagement with the municipality, and like right now we're looking at this potential project on parkland, and which I think would be a sole source contract awarded to GCI for construction of the project. Does that?
For the city?
Well, no. I guess it wouldn't be a sole source because we talked about. I guess we've talked about it as a structure where we would do a construct and contribute, and I think in the end it's going to be a lease.
Mhm.
So it would be a a lease award for a short-term license agreement, which would then be
From the
open
city
to
to
renewal from the
GCI.
city to GCI.
Well,
And we have a couple of those. Is that
And let me just, the membership qualifications, just, Becky, are 1.15, 0.050. And it doesn't mention any of that, but I think that's a good thing to be aware of. Because your company is your employer is benefiting from a lease. I guess that would be a case-by-case analysis, and the reason I say that so quickly is because one of the basic premises of the ethics code is Anchorage is a small city,
Yeah.
and everybody has interests,
yeah.
and it's how you manage them.
Mhm.
So now I should stay out of that process, probably as someone in the Department of Law. Maybe that's a good idea in this particular case. Because as a deputy, I'm already aware of that process.
Yeah, I'm sure you are.
Uh,
We've talked about it.
But maybe I just stay away from that project because there's one step of familiarity between you and I.
Okay. Just want to make sure that I know I've disclosed, as per the disclosure, we have a whole array of things that come in front of municipality that I'm involved with. GCI, and because I handle land law, and municipal law things for the company, I just want to make sure that if there's if I need to do an additional disclosure every time we have something that comes up for like a decision point, like we're getting a permit or we're getting a lease or a contract of some kind. Some of the things I'm not even aware of. I know we also have contracts to do like cloud, I think some kind of cloud-based service contract discussions going on, et cetera, that I don't even know about. But I just want to make sure I'm doing that if that's something we need to do.
Yeah, so I'm looking at, what is it, this 030I.
And just for the record, I talks about a member of the public appointed to serve on public body, which would be Becky in this case, shall not acquire directly or indirectly an economic interest in a municipal contract or engage in business with the municipality unless the municipal contract is competitively solicited. And economic interest is defined in 110 as benefit, financial interest, special privilege, or contractual relationship. You have a financial interest if you're an employee. So I think if you go through all these little dots, that Becky probably does have a financial interest or an economic interest. And so this would tell me that the GCI contracts have to be competitively solicited, which most of them would be because they're large. I don't know if there's any.
I think we do have, I think of it only in context, like we do have a few cell tower projects existing and proposed, which we build pursuant to short-term license agreements on property owned by various arms of the municipality, AWU, MLNP, and then just, I think, from the Parks and Rec, most recent. So. I don't think there's a competitive process because just the nature of that kind of lease, it's not like there are 6 other people who are wanting the same spot for a cell tower.
And this wasn't the context of this provision, I don't think. The question is, do you have an interest, an economic interest, do you have a contractual relationship in GCI's, in a let's say, $200,000 GCI business contract? Well, that one's competitively bid, so
Right.
do you have an interest in, the little GCI tower on an A1 piece of property that's either permitted or leased? And generally, if it's small enough not to be competitively bid, it also doesn't go through the assembly.
Yeah.
They don't have the same public, notice requirements. Well, maybe what we can do is give this some thought and come back, come back with a recommendation. I'll ask
Okay,
Becky
I just
some
wanna
more
make sure that
questions.
I'm
Yeah, full
disclosing
disclosure.
sufficiently.
Yeah.
Part of it's because we are the Board of Ethics. Of all the boards, we need to make
Mhm.
extra careful,
Mm-hmm.
take extra, just be extra careful to make sure
Mhm.
that we're cognizant of all of these issues. So that makes sense.
Mhm.
Well, Dee, how would that, does this apply then to David's situation?
Let's see, competitively solicited.
I'm just gonna sit down with you at some point and let's finalize this. These corrections. Kelly looked at everything. Okay. What the hell? Final paragraph. It's like 2 sentences paragraph.
Well, it'd be interesting here, does it simply say that the person in David's position has to be competitively solicited? There's no other remedy, or is there a remedy here that if you do let's see, you wouldn't do a notice of intent to solicit because it's not a response to public solicitation. See, again, these are assuming big contracts that are going through the competitive procurement process, and that's not what this is.
Right.
And of course, that's the assumption that anything that's bid competitively has that safeguard.
Right, right.
And that also the assumption that anything that's not competitively bid doesn't have safeguards. Remember what do that with Mr. Trainee, you wanted to do that program, right?
Yeah, didn't we deal with that when we had the rifle coach from service? Remember, he had a small contract with them to be repairing and the air rifles that the team was using, and it was like there was no one else in state that did it, and but technically he was acquiring a non-bid contract. We sort of maybe used some sort of doctrine of necessity there or something like that. So I said, like, well, there's just simply there's no alternative in this case, and that you come to the board and it's been disclosed, and that
There's nobody like
well, there's no doubt, right?
Yeah, it's a challenging question, because I mean, I think that for large companies like GCI, like I imagine somewhere, some other board, or there's another GCI employee, or like, for instance, I don't know, like any other sufficiently large company, I'm sure has some kind of contract with the municipality and also has an employee. Even like Siri, I'm sure, like there's some kind of contract and their employees sit on boards. There's gotta be some.
Well, again, it's all that assumption, the competitive nature cures any problems, and if it's not competitively solicited. And I think, Becky, that's a really good point, because this has got to be in many other situations. I mean, again, the code recognizes that board and commission members are going to have other interests. And I mean, think of all the people on like the Han Commission who are employees of a nonprofit, and for sure those nonprofits have other contracts with the city and grants and everything else. They may never be involved with them, but they're certainly there.
I was thinking about Terry, and Terry's appreciation for purpose and intent. And the whole, when you look at the purpose and intent language of this code, the purpose and intent is really to avoid those substantial conflicts of, substantial financial and personal nature, but anything insignificant they expressly attempt to carve out. It looks almost like we just sort of missed that little piece for municipal contracts, but I would think that what Becky's described is completely consistent with the purpose and intent of the code.
Well, again, the only issue is with the ones that are so small that
Right.
they're not
Small,
competitively,
right,
and the
exactly.
same with
With the small
David's
ones.
case.
But the small
The
ones,
small ones
I know,
almost
don't give me
insignificant.
heartburn because it's hard to imagine that Becky herself has the expectation of financial benefit, which is
No,
how we
that's
define
right.
economic
Yeah.
interest,
Exactly.
right? And so it seems to me like there, it's like indirect enough that it's hard to imagine that one that's that small has that.
An insignificant
And then in David's
benefit.
case, I agree. I mean, I can't say like your situation in any way gives me heartburn from an ethical perspective, but as soon as you said it, I went, oh, but isn't there a provision that's, in some sense, perhaps a little bit unreasonably broad and ironclad, right? And I think that's what we went through with the coach. I think we just sort of did with the coach. I don't mind telling you, I think we used your reasoning that we just sort of said, I don't think the code really allows this, but what's happening here is so consistent with the spirit of what this provision is trying to get after. There's no conflict of interest here, there's no corruption, there's no bias, you have no influence on who gets awarded the contract, and it's just so happens that you're the only person that does this, and so kind of, made a spirit of the code kind of reading, which again, I have no problem, so it doesn't give me heartburn, but I would just point out that as soon as that provision of the code came to my mind as soon as that, like, isn't there is some sort of fairly strict, potentially strict language in here.
Well, it's good for Lisa and I, because we're trying to do that code rewrite, is make sure this is one of the things that is addressed.
Yeah, for
It's
clarity.
very problematic.
And there is reference in this, 1.15.010D to personal or financial interests of an official executive or employee in a matter that is insignificant or of a type that is possessed generally by the public or large class of persons to which the official executive or employee of the municipality belongs. I mean, it just seems like this is the kind of thing that we probably run into with a lot.
What was your code set there?
It's 1.15.010D. And it's just spirit stuff. It's but it
Just that, it's like 2,500 employees, right?
it's a huge class of people.
Yeah.
But it does seem like that provision that Terry drew his attention to is pretty specific in that class.
Okay. Well, I just wanted to explore it because there are things that come up, and there are a number of ones of small contracts or land matters where I specifically am the person working on behalf of the company to negotiate with the city. So I need to make supplemental disclosures.
Well, and it's interesting how even this section is drafted. Unethical conduct is prohibited, but.
But it's okay under certain circumstances.
There you go.
Make sure you keep that in the review.
Right, yeah. You might highlight that section for,
I mean-
to come
That
back
could
to.
summarize whole portions of the
I
code.
know, right. All right, are we ready to move on to the next? Or
Well, who's our co-chair? Or you're
Yeah.
are you the?
Yes, I'm the
Mhm.
vice chair.
Next one. I think you should ask for the
Okay.
vote with respect to David's conflict.
Oh, good. Yeah, absolutely. Yeah. So David's introduced this potential conflict. I think he has disclosed it in sufficient manner for us to make a sort of informed and intelligent decision about this. And so, do we have a motion to, how should we say, a motion to see David's situation as not being a conflict of interest? Any objections to that? Okay, good. So we'll take it that you have the board's blessing.
Okay.
That you don't find a substantial conflict of interest, and then David probably, you might want to say something. Although that's not a matter before.
It wasn't.
Yeah, I
that was
apologize. It
just a
was
matter of
just a
discussion.
matter of discussion that
Right.
seemed related, so maybe just
Fewer
a future
disclosures.
reference, yeah.
Right.
Okay.
Okay. Next meeting for and again, I think we've covered this with everybody here in the room, but these are the meetings that we have with the assembly, with their the Assembly Ethics and Elections Committee meeting. And I am available to go to the next one. We are all welcome to come. I mean, anybody who wants to show up one of these meetings just for fun, you're welcome to join me. I typically give them a quick summary of what we've been up to kind of stay in touch with them, and and kind of give them an idea of what we've been doing and what we're up to. But anybody who's welcome to join me is welcome. I am able to go to the next meeting. I just checked my calendar, so.
Did you want to update them on what you talked with them about at the last meeting? You talked about the disclosure problem and the
Oh, we did. Well,
Ernie.
yeah, we did. And I was trying to delicately kind of point out that we went over that. Right. So what Lisa was mentioning is that we had that educational piece that we provided to the assembly. And did I give it to them at that meeting? I think I did. That is also part of the end of the annual report back in here. And basically what we were discussing with them is, and the way I put it is, look, we're all out to look out for each other. And what we noticed was a lack of procedure in the one particular hearing that we listened to. And we phrased it, and the way I was trying to phrase it anyway, was you may do this every day or every meeting. You go through all these different conflicts, and it becomes really lax because you kind of fly through it. We came in sideways and listened to one, and it was not done right, basically.
Mhm.
And so you may think it's being done right simply because you do them all the time. But anytime something comes up in the future, nobody's going to be looking at the entire body of work of all these disclosures. They're going to look at this one meeting, this one disclosure, and they're going to say, this wasn't sufficient. And so what I was trying to present it to the assembly as, look, to preempt something coming up in the future, now would be a really good time to tighten this up a little bit. And then we provided them that information. They were very receptive, very nice. And I was trying to be very nice. I mean, we're not there to harp on them. But we also mentioned too that Terry helped me with this to make sure I get this right, but essentially the disclosure itself is something that the assembly, it's their jurisdiction. They deal with those types of things. The Board of Ethics is here simply to decide on the sufficiency of that
The disclosure. So
Not-
my thing is that whether there's a conflict or not
Right.
is up to the assembly.
It's up to the
Whether
assembly.
the disclosure was adequate enough to
Right.
judge that conflict is up to us.
Right. And so I was trying to reiterate that
Right.
that point to them, just to kind of refresh their recollection and kind of move on. And they seemed very, and Ernie, of course, was all over it. He's like, yeah, that makes a lot of sense, which is funny. I mean, I say that with all due affection because he was the one who was just like, yeah, remember that, right? So I think that it was helpful, and I hope that they were listening.
Well, Ernie actually asked the municipal
Yeah.
clerk, Barbara, to start to work on a procedure.
That's right.
Oh,
Yes,
good.
and so they kind of lay out a little outline, right?
Mhm.
And then have that handy so they can just kind of go through it each time. So
Great.
yeah.
Great.
But like I say, I'll be at the next meeting. If something comes up, I'll let you, Terry, know. But you're always welcome. Everybody's always welcome to join there. It takes like 10 minutes, unless they really want to start. I think one of them we ended up going like 20 minutes, 30 minutes, just because they were interested. That was last meeting, wasn't it? Yeah, we talked about it for about half an hour.
I would say that any time that we've had a topic, they've been
Yeah.
really interested in hearing
Yeah.
about it. So.
So I find them a lot of fun to go to. I'm really glad that we're doing these now, because we never used to.
Yeah, that's
So-
great. Well, thank you for going.
Yeah,
I appreciate it.
absolutely. Okay, let's see. Now on to 6C. Remind me what this is. This is confidentiality has been waived. Yeah.
We had both two new
Yes.
requests for advisory opinions and also an NOPV.
That's right. That's right.
And the person that's associated with those requests for advisories, I asked her to come at 12:30 in case we had any
I
questions.
think
Okay.
she just peeked in.
Okay.
Okay.
I don't know why she didn't stay, because I kind of looked at her. I didn't think about her being
Well,
a
we can
person.
see if she's just waiting
Okay.
out there in the stairs.
Oh,
Oh,
okay.
okay.
I saw you peek in, and I didn't occur to
Very
me. Okay, come on in and have a seat.
Yeah. So can you
Well,
give us a quick update or
okay,
a
so
quick background?
actually I
on this?
haven't reread them here, but
Where, is it 6C
6C.
and 6D both?
this is Joanne Inglis. Okay.
Hi.
She currently works in ER. She used to work over in planning, something, that world over there. And now she works with ER. She's our new ADA coordinator. And at any rate, she called me as City's ethics officer and said, hey, she thinks, let's see, so if you look at 6C, she's a current municipal employee. Previously, she worked in the Community Development Department for nearly 20 years. She reviewed development plans for compliance. You might as well read this whole thing. According to code interpretations, legal nonconforming rights, administrative permits, attended planning and zoning commission and zoning board of examiner meetings, presented appeals. Let's see. She was currently approached by a citizen working in the engineering field asking if she would consider consulting under, I would assume, the new Title 21, Joanne, for a fee during our non-work hours. Now, under the code, if it's contemporaneous employment, an employee wants to work for someone else, they have to make sure their supervisor knows about it, there's no scheduling conflicts, and there's no big conflict of interest. So they can work for whomever they want while they're employed. This is a little bit different, so I asked her to bring it here because she, as a current employee, is going to be assisting other people in working our system. So it's not that she's going to go out and do adoptions or work for Safeway or something. She's actually going to be assisting people in an area which she has expertise from her LOA employment history, although not her current employment history. And is that okay? And I said, I don't know. I don't know. So let's bring it to the board.
And what's the difference between C and D?
D is a whole different
A whole different issue?
issue.
Oh, okay. All right. Okay.
So we're the position you have now is a appointed position.
I'm an executive, yes, I am appointed.
Yeah. If you look under, what is it, 030. B, 2B. It says, if an appointed public body exercises monetary discretion, a member of the appointed public body may not apply for or receive substantial personal or financial interest in a contract or project awarded or administered by the appointed body during the member's service to the body for 2 years after leaving the service. Now, you left the service last September, right?
Yes.
Yeah. So, and she got appointed by the mayor to this new position. So does she fall into that aspect right there?
Ted, could you give the site again?
Yeah,
What you're
what-
looking at?
030
Oh, 30.
or 2B.
Okay, because
030
C.
C?
C2.
C2B.
Yeah, C,
because
it's
that's boards and commissions.
it's in the top of the page. Have you got it there?
Yeah.
Isn't there a parallel provision that applies
To a
to
public
employees?
body.
Employees,
Yeah.
though, I think I
So,
that.
you know-
Isn't there one in O25C?
I think
Yeah, 025C.
what we need to do is decide whether she falls under that thing. And if we don't feel she does, then it would be all right. We do.
I do.
025.
I do.
C.
I think we're under, we're under 025.
Okay. Ted, you were just in the boards and commissions, but there's this parallel provision being told in 025.
025.
So Ted, she's appointed, but she's been appointed to a municipal job, so she's an
Right.
employee.
I am an employee,
She's
yes.
an
Right.
employee, so
That's
she's not a
what I
member
said,
of a
like,
appointed
Bill,
board.
being and appointed.
So it's
So it would be C.
it seems like the key
Yeah.
one.
And
So
it seems like the parallel provision to what Ted was bringing up is G, right? Restrictions on employment after leaving municipal service. Or something. And that is
Well,
if she's been
but-
deemed to have left service in her previous position.
Well, she did leave the previous
Yeah.
position. And now she's a
So it
appointed
seems like a
executive.
municipal employee who leaves municipal service may not for 1 year after leaving municipal service represent, advise, or assist a person for compensation regarding a matter that was under consideration by the administrative unit served by the municipal employee. So this is for substantially, so that would be specific matter.
I don't view her as having left the service
Yeah.
because
Yeah.
she's
No, I
continuing to
know.
work with Randy.
Mhm.
But I think that same concept, Becky,
Mhm.
applies
Yeah, it's
in
interesting.
C, which basically says, the general provision is that
Mhm.
the employee shall not render services to or accept employment with persons or organizations other than the muni if the contemporary service or employment is incompatible or in conflict with the proper discharge of the employee's municipal duties. So that's the question, I think, is working as a consultant, basically, helping folks navigate the maze of municipal requirements, is that somehow considered to be incompatible or in conflict with the discharge of their municipal duties? And
Right,
it
and
sounds
that-
to me like it's not.
And the next sentence too is the service or employment shall not adversely affect the availability, productivity, I assume that's not an issue, independence of judgment. That would be the question I have for you then, because I'm not that familiar with what you're doing or what you have done or what you're planning on doing. But the independence of judgment in performing municipal duties, that would be the question I had for you. What is your answer to that?
Currently, I work in the Employee Relations Department. I am assigned to the Labor Relations section, so I could end up doing contract negotiations on various employee contracts on behalf of the municipality. I am also assigned as the ADA coordinator, so I will take in complaints and and determine if we need to do something based on the requirements to be the ADA coordinator for the public facilities and public right-of-ways. So that is currently what I'm assigned to do.
And how does that, again, could you just repeat for me so I understand, how does that relate to the outside of hours employment consulting that you're considering doing?
I don't think it relates at all because Title 21 is different. It's dealing with land use codes. Sure, under ADA, I might have to deal with a parking issue. Let's say our public facility doesn't have enough accessible parking, or if we can't, I may end up in a building code situation where maybe we need to have better access into the building or something within the building. But as far as it relates, I don't think it necessarily relates to what I'm currently doing.
Now, if you, in that ADA appliance and stuff like that, where if it comes to something, if they're asking for you to consult with, or asking you as a consultant to give you some advice on that, how would you handle that? Would you say, no, I can't?
I wouldn't take anything that was dealing with a municipal contract at all, or
No, but I mean,
advice.
it would, you'd be using your present position to advise them. Yeah.
Yet you'd have to do it for free.
I'd have to do it for free.
That's
you
right.
mean if they were coming to me and that would
Yeah.
have to be definitely, I wouldn't charge for something like that.
Okay.
Yeah,
Okay,
yeah.
That's,
Yeah.
and then,
And although I think that G, the restrictions on employment after leaving municipal service, may not technically apply, there is a good point in there, and it's probably where I've suffered some hesitation without looking at this provision. May not for 1 year after leaving municipal service represent, advise, or assist a person for compensation regarding a matter that was under consideration by the administrative unit served by the municipal employee. That's probably a pretty good restriction, though, to say, hey,
Mhm.
yeah, we think this is an okay idea, but we think you should look at this paragraph G and follow its dictates, although it doesn't strictly apply. In other words, you clearly wouldn't take compensation to help someone navigate something that you were pretty deeply involved with.
No.
You know, you would. So I think the spirit of this probably should apply.
Oh, definitely.
So in other words, she can't work as a consultant on matters that she worked on when she was in the planning group or community development group.
Well, for a year,
Makes sense.
you should have a stricter restriction probably in some legal city. Or should you have a super strict? But, and the reason, again, I asked Joanne to come here is because she did a lot in this area, and she was quite a mover, and now to assist other people, but does that presume that assisting other people isn't in our best interest? That really assisting other people is to get them to navigate the system correctly and to the benefit of both the city and to the person who's retaining Chelan. It's a little attorney adversary stuff.
Well, but I guess that would be the nature of the work
Right.
then, right? So the nature of the consulting that you would be doing would just be helping developers, people
Yeah,
who.
basically, right now, the one that has approached me is an actual engineer.
Okay.
And although he may have a lot of experience in building, he doesn't have as much in Title 21. And
Okay.
so he wanted to be able to consult with me for a fee about Title 21 issues.
And then would that be a lot, the new Title 21, I mean, the new
Yeah,
code?
yeah, right now, new Title 21's in effect, so I suppose, you know, if I'm looking at history, I could be looking back at all the Title 21's, the versions, but new Title 21.
Which is new to everybody, so.
Yeah, right.
Right.
And it's got new projects going forward.
Yeah.
Really.
Yes.
I have a question under C, 3. It says personnel rules and policies applicable to the various classification types of municipal employees shall provide for disclosure, administrative review, and management of potential conflicts of interest in contemporaneous employment. And I'm wondering if you've looked at the personnel rules for your position, or if you,
My current position? What do you mean? by
well,
that?
personnel rules and policies applicable to the various classifications. I don't know if that's something that needs to be reviewed. Or if we
I
might
can
have
tell you that
some
I don't think it's there. I don't think there is much more than you need to, personnel rules say you need to let your supervisor know what's going on. So it's
okay.
not
Yeah.
very
It's not very
helpful.
detailed.
And we were developing a form, but one size fits all wasn't particularly helpful other than getting the very basics. In fact, if anything, if I had my way about a policy, it would say if your ethics officer is uncomfortable, you're going to go to an ethics board like this and let the ethics board weigh in. Because they're either very easy or tough, and if one doesn't help. Yeah, so you're absolutely right, yeah.
In your consulting, would you be doing any like advocacy for people? Would you be appearing at hearings for them?
I don't
or-
plan to. I don't plan to.
Because I think that would be the one thing that might give me a little bit of heartburn.
In the same
about
way
it,
by the board where you're advocating and then you step behind the board and.
Yeah, and then when you look at G, like that would be, I think, what's the logic of G? One of the logics is that you leave city service, you have all this influence, the people know you, and in your kind of case, you'd be explaining probably to the people making the
Right.
judgment what the Title 20 really
Right.
means, right? You know, like,
Yeah.
and that would be, you could imagine, from the perspective of like, equal opportunity for citizens to have equal access to the, you could imagine a problem being able to hire away a city expert who's just finished developing something
Yeah.
like this.
Yeah.
But advising and consulting, that doesn't give me, I mean, that sounds efficient, that sounds
Yeah.
good.
No, I don't-
Advocating and representing, that at least starts worrying me a little bit. But even then, only in G, and I think it would only apply if we really thought you had left city service. I think the C really just applies to your current position, and that would it in some way, impair your independence of judgment or your impartiality or your ability to do your duties. And given your current position, I don't see a relationship between your consulting and your current position. And if you're not going to be engaging in advocacy, I'm not worried about G either.
Yeah, I don't intend to go to any boards or commission.
And just to be clear too, it
Or
looked
the
like,
SMU.
it looked like from your, this is all outside of work hours.
Yes, I wouldn't
And-
do this during work
and that-
hours.
And that would apply to the availability, productivity. I didn't mean to skip over those earlier, except I just assumed that that wasn't a problem. But just to confirm, this, I get the impression right now you have one person who's contacted you.
Yeah.
Do you know whether there are other people lined up behind this engineer?
have
Or
no idea.
you don't know, right? So
Yeah.
as of right now, there's no apparent effect to your availability or productivity in your current position with the municipality. Is that right?
That's right.
Okay.
And this is, my career, so I would rather,
Right.
I'd make myself always available for the job.
Right. Okay. All right.
Well, it would seem that the board should rule on whether they think there is any kind of current conflict of interest under the contemporaneous employment. And by the way, those factors you brought up, I leave those more to the supervisor.
Right.
That's to work out with your administrative
Right,
unit
absolutely.
more than us, but then the second thing is does the board want to condition any of this or their findings on some principles in G? I mean, Terry has identified the advocacy, the appearance, then we are putting some additional conditions, which I think is fine. I don't think we're making law, because I think the spirit of it is that G section.
Well, yeah, and then there's always the public trust,
Yeah,
you know,
yeah,
kind of
yeah.
catch-all, right, you know, and then that would,
And that might be that the board is guided by G, which is a time period. In other words, in 5 years from now, certainly she should be able to advocate and
Right.
maybe, so I think it's a 1-year time frame there for the advocacy and the appearances. Because I think, Joanne, you would have a powerful appearance either before the assembly or either of the two boards, two or three boards. But I think that's right, that Terry, that you would have a very powerful presence there. So at least for the year.
Is there any chance that in your current position you still might be part of discussions about, internal discussions about potential code changes or how the code is going to be applied, which would then be, and I ask in part because I know you and I have spoken about a cell tower project fairly recently because I had talked to you when you were in your previous role and wanted to figure out what to do. I'm wondering if you're still if there's still like a chance where people in your former department might call you and ask for help or tell you they're thinking about something, which would be information that you then would possess that a non-municipal employee wouldn't possess that could be a benefit to your consulting clients, or if that's kind of a stretch.
Sometimes I get calls from the public, but I defer them back to the department because I haven't been there for 6 months. I will say that I was part of the team leads for the recent marijuana. I'm handling the personnel rules part of that. Although I may have known what was going on with the other parts of the marijuana, which passed last night at the assembly. But I didn't write any of that code or anything like that. I just happened to know about it. But as far as the department, sometimes they call me, but they generally have a question about what I was doing or if I have a letter. For example, the law department, we currently are in some type of court case, and I had to go through all my old information to see if I had any information for disclosure for that case, and I wouldn't be involved in doing anything on that case as a consulting. And I don't even think I'd be asked to consult on that anyway.
Okay.
So I may have been called a couple of times in the last 6 months.
Okay.
I think that's a good question, but it probably is a manageable conflict to be handled responsibly by Joanne.
Procedurally, should we see if there are more questions on this particular subject and then ask her questions on the next one and then go into a discussion on our conclusions?
I think they're pretty separate personally, and I think also we need to handle that NOPV. So I'm actually just going to wonder whether to do this one, but maybe save, well, they're related, or is to save the other one till next time.
I wonder if we should set up like some sort of management plan about that. I think that's a really good point. Now, you know, now that I think about it, maybe like a letter to the planning department sort of is to say, you're now engaged in this consulting business, and a certain discretion should be now exercised when just discussing future changes or any sort of like insider information that then might trickle down and become an unfair advantage for your consulting clients. I mean, I think it definitely could be managed, but I do think it's something to highlight. I think it's, I mean, we all sort of know what it goes like in this building that you have these experts. Even if they're not in that department anymore, they're the person that you're going to go to. And on the one hand, I could see going to saying, like, how would you interpret this part of it? But when we start saying, well, let's go to you and talk about changes we're anticipating, wow, that is something that then, for your consulting clients, geez, I mean, you might actually have the duty to tell them about, these potential changes, right? And that that's a real problem, right?
Nobody's come to me the only thing was the marijuana team leads, and I was only on there because of personnel rules. But as far as, nobody has called me and asked me about potential changes in the code at all.
And David, maybe I can reverse what I just said and summarize real quickly. The second request, let me just do it quickly, is whether she as an employee could serve on one of the planning boards. There's the three main ones. And there's some legal issues there, but she brought it to me more as a conflict. But interesting enough, when she brought this other question to me, I said, wait a minute, now that affects your first question, which if she can serve on one of these boards, if it's not a conflict of interest for her to serve on one of these boards, then will my Title 21 consulting business prohibit me to serve on the board or commission? And I sort of feel like that question may be answered without us having to answer the other question, that if she's going to do this consulting business, is she at all limited in serving on one of those three big boards? But don't people already serve on those boards that have interests, like the surveyor?
Right, it was
And
being managed in
so again, so that maybe it's not, it doesn't help, it doesn't end the inquiry at all. Because there's every other person serving on those boards has some type of interest that on occasion comes before the board and they have to recuse themselves. I can say I'd rather spend a little bit more time on this issue to bring it to the legal issues to the board. Which
Sure.
will involve
For the next hearing.
yeah,
For
on
the
the
next-
second one, not the first one.
Okay. So, I think at this point, do we have any more questions for?
Joanne.
No, but I wanted to
Discuss
further
this.
what you said. I have
Yeah.
no question involving her.
Because I just want to make sure we can let her go as soon as possible. Do we have any other
Oh,
questions?
I guess just
Yeah.
one, just quick, your employment with the city's been continuous though, so
Yes.
so there was no point where sort of like you left city employment and then came back into
Never
your
left
parents'
city
employment.
Okay.
But you want to know whether you can be appointed to a board? Which board?
I haven't decided. What happened was, the board thing came up first, before this consulting thing came up. And what happened was I found that these boards they weren't able to fill the board seats, especially on the zoning board. And sometimes they weren't able to do business because of conflicts, or they didn't have enough people, or a short board. And so I just kind of threw it out there and said, do you guys want me to, if I am permitted, to temporarily serve on the board? And I've seen other municipal employees on boards, I've found,
Well,
as we go through this.
Anchorage Community Development Authority, the mayor appoints two municipal employees on that board.
Mm-hmm.
And there's also two assembly members
Mhm.
appointed on that.
Oh,
So, I mean, that's pretty much.
Well,
that's
do
set.
you mind if I don't want to interrupt you, go ahead, Joe.
And then the difference in some of the boards is when some of them can be adjudicatory, like the zoning board or the planning and zoning, versus another board that may not be. So that is where the conflict or the confusion might be coming up. And so we have people on some of these boards, and anyway, so Dee and I talked about it, and we thought we'd bring this one forward.
sure.
Just so the legal analysis is, some of the boards are, as Ted states, it's in the code that you have to have certain types of people. And those you generally will have a couple of employees. A couple of them say, and you can't have employees, like the ethics board. So those are different to me. And then there's the other boards that don't say anything one way or the other. And it's been a running debate between Assembly Council and Department of Law. The Assembly Council said, wait a minute, the boards and commissions are so everyday people can fill these boards and commissions and contribute to government. They were not meant to be a place for employees. And Department of Law saying, well, if that was meant to be, then it should say that in the code. And you're putting us in an impossible position every time to make this debate. And I okayed, for instance, a police officer being on the Animal Control Board and was admonished for that by Assembly Council. Because I read the code and it didn't say anything about it. It couldn't happen. You can never get anybody on the Animal Control Board. So it's because they make a decision about whether to euthanize animals. So at any rate, there's been an ongoing debate. Jill Anderson was brought in another level in terms of she has the expertise, but what about conflict issues? Again, she's a very well thought of member of those departments and has appeared in front of the zoning commission. And so my advice to she and the municipal manager was put it off a year and then bring it back. At least wait out the year. There is no magic year, but then matters you worked on aren't going to come before that zoning board. Then let's get back to the pure issue of an employee on a board or commission, not someone who's had major influence within that sphere. So, but then when she was going to bring this other one on, I said, well, you might as well put that one on now too. So one is sort of the legal question of employees on boards and commissions where employees are not either prohibited or designated to serve. But again, that's a policy, maybe policy consideration. And maybe that's sort of interesting. I mean, these are administrative boards and commissions, most of them. Maybe that's a mayor decision that they should put out a policy. But also, one other thing was the adjudicatory. We have taken the position that an employee may not serve on an adjudicatory board because it's an adjudication with the city. And so you as an employee are here and your master, the city is here, and really isn't that a conflict? So we've at least taken the position in adjudicatory settings that an employee should not be on those boards.
And that doesn't extend to board sitting in quasi-judicial capacity.
Well, we don't know.
Okay.
So how far does that go down? You're right.
Yeah.
So it probably needs to be flushed out at some point. Again, for me, it wasn't too complicated with Joanne's situation because I think she had so much involvement with the board now that she was willing to serve on. Was that a good idea?
What about serving as an ex officio capacity?
And that's always a possibility. You can't vote, and I forget the procedure for that. There's some rule about ex officio. I have to look it up again, but I think that doesn't help them fill their quorum requirements and the voting requirements.
Right.
Oh, yeah.
I mean, you could always appear as a member of the public.
Oh, yeah.
Okay.
Just give me a little work on.
Oh, sure. So, unless we have any other questions, thank you very much, Tom.
Thank
for
you.
coming tonight.
Thank you for your time.
These have to be in writing. I agree. I think it makes sense to come up with it. I don't mean to jump ahead. It sounds like what we've been able to do is come to at least a consensus that this is okay so long as it's managed. Is that
On the first one.
on the first one? The second one, I would welcome your input after a month of research or
Yeah.
whatever you
Let me
come
do
up
some
with.
more research on
Then
that.
come back, because that sounds like like you say, a purely interpretation, code interpretation type of a question. So, if that is indeed the feeling of the board, I suppose the next step is picking somebody to draft that. But I don't mean to jump ahead. Does anybody have any further discussion at this point if they want to jump in before we?
What's the number one?
With number one, not number two. We're not going to decide number two right now.
Right.
Dee's going to come back with some more, and it seems like number one is a little bit more pressing in timeliness because
Yes.
she may have somebody who wants to hire her right now. So, but two, it sounds like it's not quite.
Oh,
as
I've had her
pressing.
sit on that for 6 months already.
Right, so that could work too. But as far as issue number one, does anybody have any further discussion on that before we assign this to a writing assignment and then kind of move on?
Well,
I
go ahead.
Yeah.
Go right ahead.
Okay. I was going to say, in terms of under the category of the work being managed, I would say specifically, I would agree that we should, the spirit of G should apply. It seems to me like otherwise it's illogical if you could suddenly go and advocate
Right.
in the exact manner that you just left, just because you moved from, whatever union relation to something else. So I think that spirit should apply. And I also would say there should be some internal, or advice that the consulting should not be permitted to include any insider information or information gleaned in the context of employment that could impact. I don't know. I think it could be. It's both questions about what code changes, but also, I don't know, the context. You learn that somebody else is proposing a project because you talked to somebody who has a question. Oh, you worked on, assisted living facilities. I just got an application for one over here, and suddenly that is used to a client. I'm wary of that kind of information passage that comes with employment But I think just some kind of line about advising that needs to be explicitly carved out from what can be provided and.
Oh, that makes sense.
Kind of like lawyers with confidential information that
Yeah.
they retain for one client and then they move over to
Another client, and you can't be like, why?
Yeah.
I know we're
Yep.
doing
Got
it.
it.
Yeah, you can pay me for that
You're
information
told me.
that I know about what's going on in the city or whatever.
But,
Only
you
that's
know,
like a lifetime prohibition
Yeah.
against using.
I feel the same way that, you know, if there's some way to, you know, I don't want this to set a precedent,
Mm-hmm.
you know, so,
What precedent are you trying to avoid?
well, if it's a similar person come in, you know, they need to be decided on a case-by-case
Oh.
basis, you know, and not have someone,
Mm-hmm.
you know, read it and see that
Right.
she got away with it, so, you know, they don't even fill out a form or whatever, you know what I mean?
Yeah.
I don't want it to, which is a lot what you said, you know,
Mhm.
we gave her pretty strict, things she could do and not do, you know, won't talk to her, and, you know, and I don't want that, you
And
know, give them an inch, they take a mile type.
Ted, and this is not uncommon. Her situation became a little bit more involved and embroiled, but it's not at all uncommon. You know, I get requests as an ethics officer all the time about, I want to do consulting, and it's something that touches the city. So that, isn't that uncommon? So whoever might be writing it,
Mm-hmm.
could be, I like that point, keep that in mind as to what
Yeah.
we're saying to other people. Keep that in mind as we do our code rewrite too.
You know, this
Might be
decision only
something-
pertains to this.
Yeah.
Sure. Sure. My proposition is to send it to Lisa. Do you have time to draft this?
I will do my very best.
Okay. You're our best shot.
Just because we can't pick on Becky 2 weeks in a row.
Yeah.
And that's the only reason.
She won't
So
come
let
next
me just
time.
Yeah.
rephrase what I understood this group to say. That we think that the provision that really governs here is the provision in 1.15025C, which talks about contemporary service and employment of municipal employees.
And guidance can be drawn from G.
Guidance can be drawn from G. We think it would be illogical to not apply G in this particular instance. And that would apply both with regard to kind of the insider information / confidential information
And
aspect
public
of it.
advocacy.
And public
And
advocacy.
there's a strong appearance of impropriety there.
That's right.
Agreed.
So
That's
add
right.
that in there too, and
Yeah.
sure that's why that's in there.
You guys can
Yeah,
do
I think
the
it's
hard
a, you know,
ones.
it's the public, it's the
Perception.
various public trust requirements in the
Yeah.
code that I think allows us to use G, even though she hasn't technically left municipal service. But there's still, the point of G is actually still quite valid.
Right.
The underlying ethical point is really quite valid for this kind of case.
I think it undermines the intent of G if you could evade it by hopping over to a
Right, just
different
transfer
municipal
it,
job
yeah.
and saying, well, great, now I can shepherd people through this huge controversial project that I was just part of
I
and
just
make all
finished.
kinds of money.
Absolutely right.
Okay, very good. So
Right.
let's, can we move on into, what's next?
The NOPV.
The NOPV. I need to step out for 2 minutes.
Can we take a 2-minute break?
Can we take a 2-minute break?
2-minute break.
Or unless you want to start off with an introduction.
No, I think we should.
Okay, let me take a 2-minute break.